SJC-11520, Michael Moe et al. V. Sandra Edwards.
All right, let's proceed. Good morning.
Good morning, and may it please the Court. On July 12th of this year, a new law went into effect. This law replaced an absolute prohibition on Internet publication of Level 2 sex offender information with an absolute mandate that it be published in all cases with no possibility of an exception. In this case, we challenge the retroactive application of that statute. As the single justice found, for the 6,074 people who were classified as Level 2 offenders before July of this year, SORB has concluded, at least implicitly, that Internet publication is not justified. Applying the amendments...
But public availability is.
Public availability is, which is a term that is not explicitly defined by the statute, but rather the meaning can be discerned by looking at what availability is associated with the Level 2 classification.
Well, let's assume for a moment your client, or any client you might have, has been convicted of a crime, and I, John Q. Citizen, wants to find out. So I go on the internet, I go to the Criminal History Systems Board, wherever. I can't get that information, can I?
Cannot find out what crime the person was committed.
Yeah, whether your client, yeah, can't get it.
That's right, that's correct.
It's against the law. It's not.
That's absolutely correct.
Okay, so, but if I go down to the courthouse where your client was convicted, I can go to an index and I can get that information because it's publicly available. It's public.
Yes, Your Honor.
So if the legislature were to change the Criminal History Systems Board Corey statute and say, no, we think all convictions ought to be available over the internet, problem? Same problem?
Well, it certainly wouldn't be the same problem because this court has made
It was
clear.
illegal before, now it's legal.
But this
Public,
court,
but now it's broadly
this court has
disseminated.
made clear and has been made clear since the first case is addressed in sex offender registry that sex offender registration notification is fundamentally different than those kinds of publicly available documents. And the reason why is it doesn't just give the information that is otherwise publicly available, but labels a person as being a dangerous sex offender.
Well, if I go down to the police station to get information about your client, I get the same information, don't I?
You do, but there are a couple fundamental differences between those. The first fundamental difference is that you actually do have to walk in. This is in order.
Yeah, and I have to go to court to get the court file of your client's conviction, okay?
There are two important restrictions, though. One is a restriction on how you get that information, and then the other restriction is on who that information is available to. If you go into the courthouse if you go to the police station and request information on a Level 2 sex offender, you, in the presence of a law enforcement agent, have to fill out a form giving your name, which you don't have to do when you go on the internet. For the website, there's no requirement that you make a ID or anything like that, so it's anonymous. You have to identify yourself to law enforcement. You have to state that there's a reason that you need this information, and then you can receive information on your own town's Level 2 sex offenders. What's different about going online is that now it's unrestricted in terms of what information you could get for the geographic location. You could get information for any place in Massachusetts, and you don't have to live in Massachusetts. So no longer is this tied to the remedial purpose of the statute, which is protecting the public in Massachusetts, but is available to anyone.
We said the same
anywhere.
thing about Level 3. Level 3 wasn't disseminated by internet until 2003. What if the legislature had, at that time, amended the statute to include both Level 2 and Level 3 information available on the internet? Would that have been a problem?
Yeah, there would have been problems. Well, this court found in code that there weren't problems for Level 3s, but there would have been problems for Level 2s because all the Sex Offender Registry Board has found for Level 2s is that public availability of their information is needed. That was true in 2003. It's true now. Now we've had until July of this year the added protection of having an explicit prohibition on internet publication of their information.
There's an explicit prohibition on internet publication of criminal records as well to the public.
True, and that may frankly, I had not fully thought through that issue before this argument, but I can say that there is that fundamental difference that this court has made clear since at least 1997, that when you're talking about publicly available records, that there is a distinction between that, even when the court records are public, and what happens with sex offender registry information. Because this isn't simply giving out public documents in a different form, but is adding on top of that a government-endorsed label of someone as being a dangerous sex offender.
Plus,
Or a convicted felon.
Or a convicted felon, but that, I think that what certainly would be different and what would raise the same kind of constitutional problems is if we change the quarry laws to say that the state is now going to be giving out information to people, labeling people not just felons, but dangerous felons. You continue to pose
Well,
a
you'd have
risk
to have a
of
hearing.
recidivism.
You'd have to have a hearing to determine
You certainly
what
would
level.
have a hearing.
And you've already had a hearing to determine dangerousness.
But this would be the equivalent of having a hearing and having a finding at that hearing that that information is not going to be posted on the internet, but rather is only going to be available to people who come into the police department and fill out that form, identifying themselves in the presence of a law enforcement agent, and then just get the information for their own town, and then saying, despite that finding, we're now going to put it on the internet.
are you basically saying that internet publication is active dissemination?
For the retroactive application of the statute, I don't think you need to address that issue. What I think is clear is that this is not public availability as that term was defined before July of this year. Because before July of this year, public availability was a term of art that, while not explicitly defined by the statute, the meaning can be drawn out by the notification associated with level 2 offenders. And it involved two things. You could do what we've already discussed, which is go into the police department, fill out this form, and get information about any level 2 sex offender in your town or in your geographic area. Or you could send a form off to the Sex Offender Registry Board, and that's more limited. When you send the form off to the Sex Offender Registry Board, you're not doing this in the presence of a law enforcement agent. You're still identifying yourself, but then you can't even get all the information for everybody in your town. You can only get the information about a specific person. You can say, is my neighbor a registered level 2 sex
Joe
offender?
Blow, I mean, you have to identify.
That's right. So, and that distinction, I think, is telling, because we know that there's this added protection by forcing people to identify themselves in the presence of law enforcement, because then what happens if that information is misused? Well, law enforcement already knows who has gone in and requested the information.
So is this just a question of creating a slightly different internet format so that one must provide their identifying information in connection with a request to get this kind of information?
No, it still certainly would be different, and we know that it would be different because of what we know about the way the internet works for the past 10-year experiment we've had with putting level 3 information on the internet.
What is that experience, and what's the evidence that would suggest that there's been any undue harm in that regard?
Yes, Your Honor. So there is evidence that is fully supported in the record and is reflected in our agreed statement of stipulated facts that since 2003, there has been a proliferation of websites that have taken sex offender registration information from SORB's website, bundled that information with advertising, and then reposted it on their own websites, so that this information then becomes available not just while that person is still registered and still has, under Massachusetts law, their information on the internet, but even after they're no longer required to register, or where they're at a level where that information should no longer be available on the internet. And in addition to this, that, I guess, profit motive of these websites, there's also at least one website, SOAR Archive, and this again is fully supported by the record, that has actually told registered sex offenders that they have to pay money in order to get their information on, and then even after they've given that money.
Is that a violation of the law?
It is a violation of the law, and as far as I am aware, and the record reflects this as well, no attorney general in the United States has taken any efforts to do anything to stop it. The only efforts that have been taken is a private federal RICO lawsuit brought on behalf of the sex offenders themselves.
That's pending, is that right?
That's pending, that's right.
Well, I take it if someone goes to the police station and requests the information about a level 2 sex offender and misuses that information, it would be the same thing. It'd be a violation of the law. Maybe they'd be
That's
prosecuted, maybe not.
You're absolutely correct, and that is one of the significant points of why it's important that people have to go identify themselves.
So is it just a question of creating an identifier.
So that's one aspect of it. The second aspect of it is, who is this information given to? You know, what is the scope of the dissemination of this information? And under current law, it is carefully regulated. And this isn't just something that the legislature came up with. This court had a number of cases that said that earlier versions of the statute were unconstitutional, and they revised the statute in order to comply. And this, I think, is an effort to comply with the Doe 2 decision, where they really needed to link the notification up to the remedial purpose of the statute. So under the statute now, it ensures that for level 2s, who pose not the highest risk, but a moderate risk of reoffense, that the people who actually can have access to that information are the people they're actually likely to come into contact in their daily lives. So for this reason, people can get this information about people in their own communities, but not elsewhere. But what will happen, and what has happened on the internet, is that people, once this information is posted on the internet, it's not just people in your own community who need that information in order to protect themselves getting that information, but it's people like the people who run the SORA archive website coming and getting that information from a distant state for no reason or for
Isn't that the same
malicious
argument that
reasons.
was made about, with respect to level 3 offenders being put on the internet, that this would now be a much broader dissemination? This is different than active, whatever the word is, active.
Active dissemination.
Active dissemination.
And that's exactly right. What's different about level 2 offenders and level 3 offenders, for level 3 offenders, they've been found to be the most dangerous of the dangerous.
Well, hasn't the
And
legislature made a determination based on its own experience that level 2 offenders also pose a serious risk?
This court has made clear, though, that that determination has to be made on an individual case-by-case basis after a hearing, and what the
Perhaps a
hearings...
moderate risk. Maybe the legislature decided a moderate risk is a sufficient risk,
But-
that publication beyond publicly available is warranted.
The sex offender classification system does not just, though, look at abstract issues of the risk posed. Instead, it looks at two issues. One is, what level of risk do you pose? And then what level of notification is needed to protect the public because of that level of risk?
So
So for-
I wanted to ask this. Under the pre-July 12th law, for a level 2 person, I know it's in the statute, but you have to, the board has to find A, the moderate risk, and B, internet publication is not necessary? Do you have to make, do they have to make that finding?
So what they had to find was that that active dissemination was not needed, because if active dissemination was needed, then they were mandated to make the person a level 3. But that what was needed was public availability of that information. And public availability was not defined by the statute. So we have to look to what kinds of dissemination were associated with level 2 classification. And what that meant was this very limited, heavily regulated public availability of the information. But also what it meant, and this was explicit in the statute, was that it shall not include internet publication. And now with no additional individualized consideration, the legislature has passed an amendment to those laws that eliminates the prohibition and makes it mandatory. And that is what causes the constitutional problems here. But even beyond the constitutional problems, I think those can actually be avoided simply by reading this statute to only apply prospectively. Because this court has said repeatedly that as a general matter, all statutes will have a prospective application unless it is unequivocally clear that the legislature intended it to apply retroactively. And here, what the other side has done is to show language within the statute that certainly, I don't dispute, is consistent with a retroactive application. But being
And the basis, and why was this statute passed? Why was it proposed?
as far as I know, there is... well, there
Because it
certainly
was a
is-
very serious level 2 offender who committed serious offenses.
if we're thinking of the...
Concern
If
among-
we're thinking of the same case, Your Honor, that was actually a level 1 offender, so this statute would actually have no effect on what happened in that case. So I don't know what motivated each individual legislator. What I do know is what effect this is going to have on the legal rights of 6,074 people.
How are your legal rights changed?
The way the legal rights are changed is that before July 12th, if Sex Offender Registry Board put a level 2 sex offender's information on the internet, that person could have gone into the Superior Court and successfully filed a lawsuit to prevent them from continuing to post that information.
And I take it if the state posted someone's criminal record for public dissemination, your client could also go in and seek an injunction saying that's against the law. How are legal rights affected?
I think that's right. So, I'm sorry, Your Honor.
What I'm saying is, so someone, if the state posts something, a criminal record,
Yes.
he could go into court and say that's against the law, but are you suggesting the legislature could not change the law and make all criminal records available publicly?
Well, I
Maybe
think
by internet?
it certainly would raise some kind of constitutional issues, but those constitutional issues, as this court has held, at least going back to 1997, are fundamentally different than those associated with sex
I'm wondering
offender
how your legal rights have
notification.
been changed. Some of the consequences may have been changed because more people will know, but how have your legal rights been changed?
Well, your legal rights have been changed because your absolute statutory right to be excluded from this online database has been eliminated and replaced with an absolute mandate that that information be placed on the internet, yet you're not given any individualized consideration. This is done based on this sex offender registry classification system that's already occurred that did not have before it. If it had the issue before it, the issue was decided against this position. It was found that the information didn't need to be on the internet. And now, despite that finding, and despite this previous prohibition on placing the information in the internet, this law would require that it be placed on the internet in all cases, no matter the individual circumstances, and no matter what the result would be of any kind of hearing that would be held. And for those reasons, the statute shouldn't apply retroactively.
Thank you, counsel.
Thank you.
Good morning, Your Honors. John Stephan, Assistant Attorney General for the Board. The amendments are constitutional as applied to these plaintiffs because they are reasonably tailored to serve an important public interest that far outweighs any additional burden the plaintiffs may claim. And if I can state at the outset to respond to the point made by my brother concerning the harm that's shown in the record. While it's true that the statement of facts, the record shows that there is a proliferation of third-party websites, there is an absence of any harm shown in the record that results from the publication of that information on those websites. There is no affidavit from any of the 6,000 class members showing harm that would result from the availability of their information.
A little hard to show if it hasn't been published yet.
Indeed, but there is also not a single bit of evidence in the record from a level 3 sex offender whose information has been available on the internet for more than a decade. That absence of harm is substantial and needs to be reckoned with in assessing whether or
Well,
not.
except that the act of dissemination is something different in the two classes of people.
Absolutely, and this court and the United States Supreme Court has held that internet dissemination, internet availability of information is not active dissemination. The plaintiffs assert that they are one and the same. That is the basis for their argument that this somehow converts level 2 offenders into level 3 offenders. That isn't the case. Level 3 offenders are subject to active dissemination. They are also subject to additional restrictions, including the possibility that they might be labeled as sexually violent predators. Neither of those apply to level 2s.
All I was suggesting was that because level 3 offenders are subject to active dissemination, the effect of the internet publication may be different for them than for a level 2 offender. And a level 2 offender doesn't have any history because the statute has not gone into effect.
Indeed, but the level 2 offender is one for whom the board has already found in the course of the classification process that their degree of dangerousness and the risk that they will reoffend warrants their information being publicly available, which is another reason why the plaintiff's claims of harm do not outweigh the significant interest that the public has in accessing this information on the internet, because the plaintiff's information is already available.
Disagree with the contention that your brother just made, that there was a statutory right to be excluded from the online database and that has been eliminated?
I do dispute that that constitutes a right that requires a recognition or an
Well,
analysis.
there was in the past a statutory exclusion
Yes,
that no longer exists.
and I don't dispute that. There is no doubt that that is how the legislature has
that-
changed this.
Right, and that when they, these level 2 offenders could in fact have sought relief in the past under the prior statutory scheme, had SORB put that information on the internet because the statute precluded that.
Yes. But I don't contend that that change is so significant as to render the amendments, which the legislature has now passed, unconstitutionally retroactive.
Right, but I mean, if that's true, then it would also, well, never mind. Go ahead.
What's important in assessing this is the significant benefits that this court has already recognized that will flow from the availability of information on the internet. It is both limited impact on this particular class, but it provides a substantial benefit.
What are
to
the
public.
benefits?
So the benefits include a broader and more practical access to the information for individuals, either parents who are caring for children or others who are caring for individuals, to access the information without having to go to the police station or without making a written request to the board. As a result, the information that they can access, they can get in a more timely fashion, they can get it with less labor and effort, and it also provides information concerning offenders who may be in violation of their requirements to register. These enable, as the court recognized in the Coe decision, the public to assist in identifying and ensuring that those offenders either do not reoffend or are not a risk to individuals that they are caring for.
Go ahead, finish.
Only to point two examples in which this may provide significant additional protections. The other side makes points about how the information is available from broader communities across the Commonwealth. This is a real value to the public in this day and age, where you may have a parent in Boston who has a child at school in Springfield. For them to obtain information about the child's exposure to sex offenders, level 2 sex offenders, parent would need to drive to Springfield, either drive to Springfield, go to the police station there and obtain the information, or submit a written request to SORB. Now, that may be a trip that be expected to be done a couple of times a year.
Once it's on the internet, this is not just restricted to Massachusetts, it's worldwide, isn't it?
Yes, but the record, and I believe that the record in this case, believe also that the court's findings in Coe support the contention that the interest in Massachusetts sex offenders degrades as you move geographically further away. So that this information could be accessed by an individual in California is not necessarily a significant harm to individuals in Massachusetts, but it may also be very useful to an individual who's considering relocating to Massachusetts from California. This will give them access to the information to be able to assess which community.
So how does this internet access work as a practical matter? You just say sex offenders level 2 and all the photos and names are printed out in alphabetical order, or do you have to ask for a certain person or a certain location?
So the database, and there are screenshots of the database in the record for you to consult. The database has been adopted from the database that existed for level 3 offenders. It allows an individual, after they go to the SORB website, click through to the database page, see a series of warnings about the misuse of information. They can then click a button where they certify that they are over the age of 18, that they need the information for the protection of themselves or others. And then you can query the database based on a number of criteria. It would include by city or town. You can search for all offenders who are known to be in violation, and you can then receive a list of the offenders, level 2 and level 3 designated by different colors, as to which ones satisfy your search criteria.
Can I just follow up on that? Is there anonymity for the requester?
The requester does not need to provide their name.
All right, and in conjunction with that, is there really any difference now between accessing information for level 3 offenders than there would be for level 2 offenders? It's the same exact process.
Through the database, it is the same process. But that, of course, does not take away the fact that community notification, which is the essential
No, there's
component.
addition to the,
Yes.
but I'm just saying, in terms of internet access, there will be no difference between accessing information about level 2 and level 3. And presumably about level 3, you never needed to give any identifying information about the requester.
For level 3 offenders, if you were requesting that information from a police station,
No, I meant on the internet.
Correct. It's the same system.
So I take it wouldn't be very difficult to require identification as an access, would it?
Technologically, I don't believe it would be difficult, Your Honor. I don't believe it's warranted in this instance where you have a community of individuals, level 2 offenders, who have already had all the process that was due prior to the board making a determination that their information should be publicly available.
All the process, but one of the considerations, presumably, as to their risk level had to do with whether this information would be necessary for it to be available on the internet.
I don't agree with your position there, Your Honor. I don't believe that actually is a factor. In determining whether or not to classify an individual as a level 2 sex offender, the question before the board was, does the risk of reoffense and degree of dangerousness warrant that the information should be publicly available? And if so, are the risks and dangers so great that they warrant the active dissemination of that information? Whether or not to put the information on the internet is not the determining factor. There are some 24 factors that go into the classification determination as to risk and dangerousness. How the information is made available by internet or otherwise is not one of those factors. So there has been no finding by the board explicitly or implicitly regarding the availability of internet information for these plaintiffs.
I take it if the legislation also included level 1 offenders, that really would be a very difficult problem for you.
That would be a very different situation here because that would not be consistent with a finding of the Board of Public Availability of Information.
One of the points your brother made was that there has to be some kind of individualized consideration for each of the level 2 people. If we publicize this is just an across-the-board approach. What about that individualized approach?
I'm not certain I understand your question, Your Honor. The classification process will remain exactly the same insofar as the assessment of each individual offender as they go before the board will still receive the same process in determining their risk of reoffense and degree of dangerousness. That's an individualized, fact-based process that involves the submission of evidence, the opportunity to have counsel present and appointed for you if you are indigent, plus opportunities for reclassification down the line. So there's a significant process in addition to all of the process that was afforded to these plaintiffs prior to their convictions. So there is no concern here that there is a broad swath or a new classification applied to these individuals. This is each one in their classification was done on an individualized basis. So I don't see that as a real concern.
Am I correct that if you're on the database that's on the internet, a search engine will capture that? So if you Google that name,
I don't believe that the record is conclusive on this point, that I don't believe that Google and search engines are able to query the SORB database directly.
how about the other databases that have now fed off the SORT
I'm
database?
not certain the record shows how the information from state sex offender databases have ended up on third-party websites. If level 3 sex offenders appear in Google results and identified as sex offenders, they could be there for any number of reasons, including media accounts concerning their convictions or other sources or from these third-party websites. But I don't believe that the record establishes that merely because that information is available on SORB's website, that it will somehow, that it can then be accessed directly through Google or another search engine without going through the safeguards that are in the SORB database. There is, I think, just to touch on the final point here, there is no concern, I think, that the legislature did not intend for this statute to apply retrospectively. There is ample evidence that the legislature intended, as a single justice found, that the legislation cover this class of level 2 plaintiffs. That's evident not only from the text and context of the law, but also from the fact that in the absence of retrospective application, the function of the internet database would, for level 2 offenders, be almost entirely ineffective for years to come, because the vast majority of level 2 offenders would be excluded from the directory of information that was available. So an individual seeking complete information from about the level 2 and level 3 offenders in their area would not be able to obtain that from going to the database. They would have to supplement that by making a separate trip to the police department or a request through SORB. As a result, you see both the legislative intent that this apply retrospectively and also the grave consequence that would come if an exception for this class of plaintiffs is created so as to exclude them from the database. So I urge the court to find that the amendments are constitutional.
Thank you, counsel.
Thank you.